Welcome to EO Radio Show, episode 27. I'm happy to have my colleague Nate Garhart back for a chat today about privacy laws and how they affect website content development, as well as online activities by nonprofits. We'll start our conversation with some basic background on when a nonprofit needs a privacy policy on its website and how to think about what should be posted on the website and where. Welcome to the EO Radio Show, your nonprofit legal resource. Brought to you by the Exempt Organizations Group at Farella, Braun & Martel. My name is Cynthia Rowland, and I'm a partner at Farella. I'm a business and tax lawyer with more than 30 years of experience advising clients on nonprofit and charity law. Through this podcast, our lawyers and guests will discuss a range of legal and business issues impacting the nonprofit world because we understand you work hard every day to make your community a better place to live and do business. Many of our programs focus on the basics, and at times we'll do a deep dive into narrow and complicated legal issues. Again, welcome to the EO Radio Show. We're glad you're here. Well, today I'm pleased to welcome back Nate Garhart. Nate is an attorney at Farella, Braun & Martel, whose work is centered on intellectual property issues, and as a key part of his practice, he works with clients to minimize the legal risks related to their branding, advertising, and publicity strategies. Online, he counsels clients on internet issues and e-commerce topics. He drafts website terms of use and privacy policies, all of which are focused on helping clients comply with Europe's GDPR and California's CCPA. And he reviews customer communications for compliance with current laws as well. Welcome back to the show, Nate.
Thanks, Cynthia. Great to be here, as always.
I want to get back to that alphabet soup of acronyms in a little bit. But to start with, let's go over some basic background. What is a privacy policy?
Sure. Great question. And that's where we all need to start. We've all seen them. We all click through them every now and again. More likely, we get emails that say, such and such business has changed their privacy policy, and we don't read those emails. I certainly don't.
I don't either.
No, but they are required. And what are they? They're a notice. They're a notice to the users, putting the users on notice of what you're collecting from them and what you do with that information that you collect from them and what they can do to control it. So you have to have those three pieces of information in your privacy policy. Some of the keys are, first of all, I get a lot of questions. Hey, these privacy policies are all over the place. I'm just going to grab one from X website. Well, as an intellectual property lawyer, I never like to hear that somebody is just cutting and pasting from somebody else's work. But separate from that, on the privacy policy focus, it needs to accurately reflect what you do, not what somebody else does. You may have practices that are very different from another company. And if you use their privacy policy, it's not going to accurately reflect what you do, and it's not going to be compliant with the law. So I hesitate when I hear that somebody is just going to grab somebody else's privacy policy. I understand that they seem so boilerplate, and it seems like just another legal expense. But this is something that the law requires, and it is slightly technical. They don't read very technical. At least I try not to make mine read very technical. Try to use plain English, but at the end of the day, they have to have certain ingredients in them that accurately reflect your business's processes in order to comply with the law.
So for my new nonprofit, I guess when I start thinking about this, a privacy policy from some similar organization, and at least read the whole thing and think about whether what I'm doing is the same, and then maybe take that with my comments to my lawyer and say, okay, here's what I'm going to do. I think this covers it. Is that an okay way to start?
Yeah, certainly nothing wrong with saying, I do something similar to this entity. That could be a really good start. The thing is, we don't know what those entities do, where they get their information, and what they have to comply with. For example, if a company really, while it's a U.S. nonprofit, focuses on, let's say, Ukrainian refugees, and they are collecting a lot of information from people in Europe, they have to comply with different laws. And let's talk a little bit about the laws that are at issue.
We get the alphabet soup now, right?
Here it comes, and I'll try to keep it to a minimum, but there are a couple of quick acronyms that you will hear me say a lot. The first is Europe's law, which is the GDPR, and the second is California's law, which is the CCPA. Now, you'll also hear the CPRA in California. The CCPA was the original version of the privacy law in 2020, and that got amended by the CPRA, but it's still the CCPA. So I will refer to California's law as the CCPA, and that includes the revisions in the CPRA. And I'll refer to Europe's law as the GDPR. So those are the two main laws that you have to be concerned about. And most nonprofits that I work with in California don't have too much concern about those laws because, first of all, they're not in a situation where they're really collecting a lot of information or targeting anything at European residents. And instead, they're focused on California or maybe West Coast or U.S. residents in general. So they're not really dealing with and not concerned with the GDPR. If, however, I talk to a client and it is something like the example I gave, and they are getting a lot of input from European residents, you have to take the GDPR into account. Now, the California law, the CCPA, expressly notes that it does not apply to nonprofits. So immediately, a lot of the nonprofit clients say, well, first they say, phew, good talking to you. I'll talk to you later. Let me know if anything happens. And I understand that, and I appreciate that they don't want to, waste effort and money where a law doesn't apply to them. But I would say a couple of things come into play that make it so that nonprofits should think about it and should still consider complying, even though the CCPA expressly carves out nonprofits. And the first reason for that is consumers have come to expect the type of rights that are included in the CCPA and required by the CCPA. So it could be just a consumer relations, a donor relations issue if you have a privacy policy or privacy practices that simply don't comply with the CCPA. So that's something worth considering. The other thing is the law could change any time. And I would say it's easier to get your privacy policy and your practices in shape today rather than tomorrow. The more data you have, the more you have it siloed in different places and you have to find it all, the better it is to get in early to avoid more complication as you gather more and more data.
Because the nonprofits, they start out small, they do things casually, and then things get complicated sometimes pretty quickly.
Yeah, success can be very complicating.
Yeah, just to back up really briefly, there are a lot of different kinds of nonprofits. Is the carve out specific to nonprofit corporations, like organizations organized not for a profit purpose, or does it refer to the Internal Revenue Code tax exemption definitions?
Boy, that's a great question, Cynthia, and that's one worth coming back to in a follow-up. I'll have to nail that down. But my general understanding is if you're not a for-profit commercial business, don't think it specifically cites the revenue code or anything like that.
Let's just put a link to that in the show notes, and then if anybody really wants to dive into that. But for now, I think it is general analytical perspective. It's fair to say that if you're not organized for profit, if you're a charity, or some other sort of exempt organization, this isn't going to apply to you. But carry on with all the reasons why you still might want to think about collecting and protecting the data as if you were subject to it.
Yeah. And by the way, there are 5 of these, and we've covered 2. We've covered that people expect those rights and that the law could change. The third one is that other states have similar requirements that you need to be concerned about if you're collecting information from people in those states. So Colorado is an example. The Colorado law expressly applies to nonprofits. So if you're collecting information from people in Colorado, you are subject to its law. And really, if you were to comply with the California law, you would check most, if not all, of the boxes on the Colorado law and be in good shape. So something to consider. And there are other states with laws. Connecticut, Utah, Virginia are the current other states that have privacy laws. And again, complying with the CCPA really puts you in good shape with those other laws. So then the next reason to consider complying now is that it's just going to continue to get more complicated. As we collect data in different ways, as the technology changes, as the law changes, it's not going to be a situation where your time complying is wasted. If you comply now, you'll be a lot of the way to complying with the new law that comes next. So it'll be a lighter lift when we get to that point. So again, I think it's worthwhile to consider it now. And then finally, until there's a federal law, assuming that your organization is located in California, complying with California law really will give you the best baseline protection against privacy claims no matter where they might come from. So it's really just it's not perfect protection, but it gives you reasonable protection against potential liability in connection with your use and collection of individuals' data.
Okay, so as I start thinking about my privacy policy, what's the basic thing that a privacy policy covers?
Right, perfect. So I've been talking about data a lot, but it's not just any data. What we're concerned about here and what we have to tell consumers about, or the users of our site, is what information you collect from them, and specifically what personal information you collect from them. So what's personal information and what makes it different than any other information I collect from them? Personal information is anything that identifies a person or a household. I get a lot of questions on the household part. We'll touch on that. But anything that identifies a person is pretty straightforward. Their name, their email address, their physical address, anything like that that I could identify an individual through would qualify as personal information. Well, how does a household have personal information? First of all, it could be an address, that a household has an address. But then I think about, in the past, I have had email addresses with my significant other, for example, that didn't identify either one of us in a sense, identified both of us or our household. That would qualify as personal information, even though it doesn't identify a single person. And so that's where the household terminology comes in. So while the household terminology is important, the bottom line is generally if you're collecting information that could identify one person or a limited number of people that live together, that's going to qualify as personal information. Now, there's one wrinkle to that that's important, and that is something might not be personal information in a vacuum, just floating there. So, for example, if I collected the information from a user that user is female, that's not personal information because it doesn't identify one person. But if I have a contact card for that person, and I have their name and their email address, and then I have in there that person is female, that piece of data, that single piece of information that person is female, now is personal information because it is tied to something that identifies a single person. So that could include gender, marital status, browsing data. A lot of times that's collected. We see what pages people go to and what pages they've come from using cookies, what parts of our site they go to. To the extent we tie that to an individual user, that's all personal information. And we'll talk about why that's important later. But at the end of the day, it's important to identify all of the personal information that you collect about a person. And let me talk really quickly, a quick aside on that browsing data. I always talk to clients about whether they track what users do on their website. And they say no. And then I say, well, do you use Google Analytics? And oh yeah, it's a huge part of our program. It's really important to us. Well, bam, that's collecting information on individuals. Now, that's not necessarily personally identifiable information because they may not connect that to an individual person, but they may. And so those are the kind of questions we have to work through.
Yeah, there are so many times, and just anecdotally with friends and in casual conversations, somebody will say like, yeah, I browsed XYZ, pillows, whatever. And suddenly I'm getting all these pillow ads in my Facebook feed, right? I mean, that's coincidence.
Right.
Is that coincidence?
No, it's not coincidence. Exactly. And, it gets more and more pervasive. Some might say invasive. I'm going to stay neutral on the qualitative judgment there. But, there was a situation where Alexa was picking up what people were talking about, and they would get ads that reflected those conversations. So a lot of data is being collected. No question about it.
Yeah, and that's not necessarily a bad thing. I mean, if I have a nonprofit that really wants to reach people interested in my topics and send them useful content, then maybe I really do want to be able to do this. And exploit always has a negative connotation, but use that power to connect people. And that's not necessarily a bad or risky thing as long as my privacy policy covers it.
Well, there's where you nailed it. That's exactly right. Most things are going to be okay as long as you get the appropriate, I'll say consent, although it's not active consent because you don't need somebody to say, yes, I allow you to do this. You just need to give them notice. You need to put them on notice that this is what you do. If they say, wow, I got that pillow ad, they should be able to go into your site and understand that the native advertising services that you use are how that happened because you're tracking where they've gone on other sites, etc., using cookies. So As long as you disclose that and they can easily find it, A, you're complying with the law, and B, fewer people will be upset about it because it's not something you're doing in secret. It's not nefarious at all.
Well, and it's kind of expected anymore.
It really is. I deal with privacy issues all the time. I deal with privacy concerns all the time. I personally have very little limitations on the information that I am comfortable with websites using because I like the convenience. I love going to a site and having all my information filled in on a form, things like that. I really appreciate that. So at the end of the day, reasonable minds can differ on that, but companies are certainly permitted to do it. And if you don't want them to do it, you have to change your practices. You have to let them know you're not comfortable with them doing it. And you can take yourself out of it. But as a company, as a client that's looking at their privacy policy, again, it's about notice, not changing your behaviors, but changing the notice and giving proper notice to your users. So we talked about personal information. You have to tell them what information you collect. You also have to tell them what you do with their personal information. So you really need to spell out why you need that personal information and what you use it for, being very specific about it. You do it by category. You don't have to say, we use it in connection with Google Analytics. You can say you collect it for advertising placement purposes or to get statistics and understand the use of your website. So you can be general about it, but you do need to specifically say what you're using their information for, what's your purpose in collecting and using that information. Next thing you have to disclose is whether you share data. I get this a lot. When I talk to clients about this, I get the answer, no, we never share data. Get that a lot. I say, okay, I get it. And I say, do you have a vendor that does your email services? That a lot of places don't actually send out their own emails. They use a service like Constant Contact. Well, if you're using Constant Contact or other email servers, you have to give those entities email addresses in order for them to send emails on your behalf. So you're sharing that information with third parties.
Oh, okay. So that's not what I thought you meant by share. Everything's outsourced for a lot of organizations.
That's right. That's absolutely right. And so it's very common to share, and share kind of sounds like a dirty word, if you will. But no, it's not. It's not a problem to share. Again, this is about notice. You just have to give the users notice of with whom you're going to share that information. And so that's a classic example is the email service that you give it to. But there are lots of those. And they could be anything from, if you had a giveaway or some kind of donate, you could use contest or raffle supply, logistics supply companies. There's all kinds of ways that you would use third parties. And again, you just need to disclose who you're sharing with. So you have to tell people when and with whom you're sharing by category. So I don't have to name that email service. I don't have to say Constant Contact. I just have to say, when we undertake sending you emails, we will share your personal information with an email service provider, period.
All right. That seems generic and bland enough. That's not scary.
It's not scary. And at the end of the day, again, that share sounds scary, but when you list all of these out by category and they're not specific, you read them and you're like, yeah, I'm good with that. Of course they need to do that. So the notice ends up being something that I think if somebody reads it, they would be comforted more than they would be frightened by the privacy policy. The other thing you need to disclose is whether when you share with a third party, do you share with them to use that information to use for your purposes, or are they allowed to use it for their own purposes as well? And if they're allowed to use it for their own purposes, it is a big difference. Again, you just need to give notice. People may be more likely to write you and say, please don't use my personal information. But you just need to disclose it in order to comply with the law. So the other question that I ask people is whether they sell data. And most nonprofits don't sell data. That's not very common. It used to be that the word sell was problematic because it seemed to include share. And so it was difficult to say that you don't sell personal information. But now with the amendments that it's clear that sharing data is one thing and selling data is another, it's easier to say, no, we don't sell data. And that's important to know because if you do sell personal information, then you need to have a special button on your site. It's a do not sell button, and it enables people to basically opt out of having their information sold.
So here's another kind of nonprofit twist on that. So I have a nonprofit that's active in some advocacy effort. I'm going to use generic word. I want to provide my mailing list to another nonprofit with similar goals. And in exchange, they're going to give me their list, let's just say. So we traded lists.
Right.
Is that sharing or is that selling? And if we're not sure, I guess it's just about risk management if the law is not clear.
That's right. Sell means giving anything for compensation and getting compensation in return. Are you getting compensation there? Yeah, I would say you likely are, but the law isn't clear on that. And I haven't seen any court decide at this point whether that would trigger the need to have a do not sell my personal information button. Now, what I would suggest is if you're risk averse, absolutely throw that button up there. But, that's not a button nonprofits like to have on their site because it creates an appearance that isn't accurate. They're not sellers of personal information. Sellers are those who collect information and then sell that to other companies as mailing lists, right? And nobody wants their name being sold to other companies. We all get too much spam, and that just creates more spam. So it creates this impression that's not really accurate. So nonprofits don't want to use that button. What I would say is just be clear in your privacy policy. Could a regulator come along and say you needed to have a do not sell button? Yes, the regulator could do that. California's privacy board could do that and say that you're in violation of the CCPA. First of all, CCPA probably doesn't apply to nonprofits, so unlikely that's going to be an issue. And second of all, if you can show you made a good faith effort to undertake the steps to reasonably comply with what the law is trying to do, which is put people on notice of what's being done with their data, and you have it laid out in your privacy policy, I think you're unlikely to get the harshest penalties from any regulator. I think regulators are generally going to be understanding when there is gray area and when you are making a good faith attempt to comply versus those that are just trying to avoid the law. And that's not the case if you're putting together a well thought out and accurate privacy policy.
Yeah, I pushed you in a little sidetrack there on sell versus share.
Yeah, that happens.
Exactly, especially with me. So thinking about the user's rights, I think that's our next topic that you wanted to cover. As a visitor to a nonprofit site, what do I have the right to know about?
Yeah, so again, this is all based on the CCPA, and that may not apply, but these are the kind of rights that donors, all consumers of all types, are coming to expect. And those rights would include, and as they're laid out in the CCPA, are, first of all, the right to know what specific personal information you have for that individual. So you obviously don't put that in your privacy policy. You don't list out that information. You just tell people they have that right. They have the right to know what specific pieces of personal information my entity has for that individual or household. The second is you tell them they have the right to access and correct that information. So if they ask for that information, you send them a list, tell them everything you have. If they say, oh, that's not my email, then they have the right to tell you it's not their email, and you need to update that in your system to make it correct. The next right they have is they have the right to have you transfer that information to a third party. So if they said, X nonprofit, it's been a joy working with you, and I know you have a lot of my information, and I'd really like Y nonprofit to have that information as well because I want to work with them and it's just easier to get it over there all at once rather than having me come up with this, and I'd like them to know my browsing habits and things like that. They can ask for that information to be transferred to that Y nonprofit. And so that can be a little tricky because this goes back to the question of, do you know what data you have for an individual? And you have to keep track of what data you have for an individual and be able to access that data, have it all in one bucket. That sounds pretty easy, but when data comes in through various directions, it's not all just listed on a contact card usually. It would be great if it were. If it's not, you may need help with collecting that information. And there are definitely vendors that will come in and do that for you and get your information properly set up so that it's easier to access for any one individual. So then the next right they have, and this is probably the biggest one, it's the right to be forgotten. the right to have you delete information. Now, especially with my nonprofit clients, I get gasps at that point because they say, actually, we're required to keep information of people, for example, for tax purposes. We have to know what the individual, including very sensitive personal information about them, such as their social security number or taxpayer ID or something like that. We have to keep that information by law. So what do we do when somebody says, I am asking to be forgotten? And the answer is actually pretty straightforward. The law has thought about this. And what it says is, you don't have to delete that information for that person. You tell them we need to keep it for tax purposes. We'll keep it for the allotted required time, and we'll delete it afterward. But you also, and here's the trick to that, is that once they ask to be forgotten, if you have to keep it for a given legal or compliance purpose, you can do so, but you may only use it for that compliance purpose. So once I ask to be forgotten, and the nonprofit tells me we can't delete your information because we need to hold it for tax purposes, and I say, okay, please delete it after 7 years or whatever the period is, and a month goes by or a year goes by and I get emails from that nonprofit, that's a violation because I asked to be forgotten. They can keep it for tax purposes, but then they can't use it for any other purpose other than that tax purpose. So that's where you have to be careful.
We've touched on a lot of topics here. And before we wrap up, I guess kind of implicit through all of this is managing the risks of violating any of these rules. Can you talk a little bit about the real risks? Are we worried about regulators coming in saying, you shouldn't have done this, there's fines and penalties? Are we worried about users of the site and a class action of some sort? What is the average nonprofit? What should we really be worried about?
Right. And this is the quite literally $1 million question, right? And it is very important. The good news is there is only a private right of action in connection with a security breach. If there is a true security breach and somebody takes my data from your entity and you didn't have reasonable security protections in place, then you could be open to a class action. Damages with that could be excessive because nobody has to prove up damages. There are statutory damages provided for in connection with a breach. Now, that said, if the CCPA does not technically apply to your organization, query whether the private right of action under the CCPA would be available to those who were damaged by a breach. So probably not, but that is the risk to be concerned about from the private right of action side. From the regulator enforcement side, there are significant fines that can be put into place. They are not limited to security breaches. They can be for any failure to comply with the CCPA. But again, what we've seen so far is they're not ignoring the little guy. It's not that, but they are definitely focusing on entities that so far have really either misrepresented what they're doing or have failed to have the required disclosures at all. Again, so either aren't doing what they said they're doing or they just didn't say it. And so I think having a well thought out privacy policy that accurately reflects your practices really is your best defense against those risks of both individuals enforcing in any way in connection with cybercrime and in connection with any kind of regulatory enforcement.
So, Nate, that was a great way to wrap this up. My takeaway for this is that for a small nonprofit that's collecting information just to send a newsletter, and we're really not nothing more than that, the privacy policy is not something to keep me awake at night. But if I'm a fledgling nonprofit that has big plans to operate internationally and build a global movement towards some important agenda with all the array of things that nonprofits can do to support their mission, then the privacy policy and the things you might want to collect and the way you may want to use your website, data gathering abilities, becomes really something worthy of more time and effort and analysis.
Couldn't agree more. It's definitely something that you need to think about, and how much you need to think about it really depends on what are your practices. And the final thing I would note is whether you're a small nonprofit or a significant one, I get a lot of questions that basically say, can you point me to a template? I've looked at what's out there, and really you can find a lot if you just Google privacy policy generator, for example. And there's lots of them out there. Many of them are free. Many of them are low cost. If you want them to comply with certain laws like the CCPA, probably have to pay something for it. At the end of the day, I don't have any problem with those. I certainly can't say that they check every box. I certainly can't say what they've looked into and what they're aware of as far as the law and the changing landscape of the law as other states come into play, as cases come down, as enforcement actions come down. I don't know how they are keeping up with that. They may well be keeping up with it. I just can't vouch for them. But I think it's a good starting point. And I think what you said earlier, going to your privacy counsel and just saying, hey, we do pretty much what this website says it does, and having a discussion with your attorney about what exactly do you do, it may turn out that pretty straightforward privacy policy is not going to be a big lift for you. But I think it's a great idea to look at things as a starting point. I just wouldn't consider them the end of the discussion.
I think that's really good advice. That reminds me, I think in our show notes, we should add the reference to our episode on cybersecurity, which is a natural follow-on to this conversation. And we'll put the links to our other episodes where Nate and I talk about IP issues. And so with that, I think that's all we're going to cover in this episode. We've gone on long enough, I think. Thanks again, Nate. This has really been fun. And I'm sure this episode will be helpful to a lot of new nonprofits, as well as some that, may have been collecting data for a while. Listeners can check out the show notes for links to more resources on these topics. And again, Nate, thank you so much. I really appreciate this.
Thank you, Cynthia. Always great to be here.
I'm Cynthia Rowland, and you've been listening to EO Radio Show, your nonprofit legal resource, brought to you by the Exempt Organizations Group at Farella, Braun & Martel. If you have suggestions for topics you would like for us to discuss, please email us at eoradioshow@fbm.com. That's eoradioshow@fbm.com. Thank you for joining us. Until next time, make a difference.